So, my name is Robert Nakacki. I'm founder of law firm Skarbiec from Warsaw. We are joined by Michael Clayson, who is a seasoned attorney, I believe.
Seasoned means old, right?
No, he's experienced attorney, practicing law in New York, but also in Warsaw, also in Israel. We are joined by his team from New York, being Bożena Diaz, who is head of tax department, with Michael Kwiatkowski, who is of counsel in bankruptcy department. And we are joined by Mikołaj Hałas, who works with me in law firm Skarbiec here in Warsaw. In this webinar, we'll be speaking about issues related to directors' responsibility, about bankruptcy, about restructuring proceedings, issues related to this. First of all, my idea is that we start with issues related to US law. We speak generally about idea of board of directors, responsibility of board of directors, possibility of putting financial responsibility for actions of the company on directors. And from this, we will move on to the Polish perspective of the situation.
Okay.
So, Michael, if I can ask you to start.
Very good. And I think what you said, Robert, is quite important to our clients abroad, that is outside the USA, on the question of responsibility of directors and officers. And Michael Kwiatkowski, my colleague, will be addressing that in more general terms. And then Bożena will speak about some of the individual responsibilities there are regarding tax issues. What I'd like to do is start out with a short presentation on an outline of American insolvency law. And I think some of the members of the audience are familiar with that, but let me just do an overview. And Bożena, I'm sorry, Carolina, do we have a way to get the gallery?
I'm sorry?
Do we have a way to put the gallery on the screen so I can see who's listening in on this?
Yes, we are trying to.
You're working on, oh,
Yes,
there you go.
yes.
Okay, all right, good. All right, so I'll start with a brief overview, and I'm going to do this on a level that I think maybe some of you already know, so forgive me for that, but I'll try to balance between as though you don't know anything about it and for those who have experience. But in the United States, unlike in Poland, our country is divided up into 50 states, and many of the laws governing business and other things are based upon state law. There are some laws, of course, that are based on national law.
Okay, if Michael, I can stop you here. For us to understand, let's assume we have a contract between the Polish company and the United States company. Let's assume we want to bring the case to the court in the United States. As an assumption, or we made a choice of law and choice of jurisdiction for United States. Then where exactly we go? We go to the state court or we go to the federal court? What is the difference?
You've asked a very good question. It's totally outside of insolvency law, but just general law. And generally speaking, we have federal courts and we have state courts. And in the case of state courts, there are issues in such a situation as you described to show that there were what we call minimum contacts, which gives the court jurisdiction over the parties. And also there are issues of venue. So one issue is jurisdiction of the court and one is venue. Where is the best place to have the court proceedings? Now, generally speaking, when you have two parties of two different states, you can ask the federal courts to decide your case based upon what's called diversity jurisdiction. Basically, there's two requirements. One is that the parties be of two different states, and secondly, that there'll be a certain amount in controversy. If it's too small, they won't take it, even if there's diversity. And no matter how big it is, unless there's diversity, they won't take it. That's generally how the federal court system works. There is one other jurisdiction, and that is over constitutional issues. So if your dispute between a Polish company and an American company in any way involved constitutional issues, they could also ask the federal district court, that's the trial level, to deal with it. Generally, one more thing, Robert, if I had my choice, and I suspect my colleagues would say the same, I prefer to go to federal court. Federal
This is
court's a
exactly
better
what I
place to be.
wanted
Yeah.
to ask the question. So if we have possibility to choose, it's a better issue to go to the.
Generally speaking, yes.
Right.
Now, there may be occasions where it's better to be in the state court. Sometimes that has to do with relationships with the judges and the local bar. But generally, we look for federal. And when we're talking about federal and we're talking about insolvency, there is a national bankruptcy code that governs insolvency. And I think everybody knows that in the American Bankruptcy Code, there are chapters. You hear a lot about Chapter 11, which is reorganization, Chapter 7, which is liquidation. And you will hear less about Chapter 13, which is individual, what we call consumer reorganization. There's also a Chapter 9. I was involved in a big Chapter 9 case, the bankruptcy of a municipality. In my case, it was the Detroit municipality. But generally speaking, Chapter 11 is used for reorganizing, and Chapter 7 is used for liquidation. At least that's how it started back under the version of the bankruptcy code that was passed 50 years ago. However, as we moved into the 21st century, Chapter 11 is also used for liquidation. It's also used for sales of businesses. In a Chapter 11, you can have a debtor, that's the party that owes the money, and then you have a committee, and the committee is made up of the creditors of the debtor. And then you have secured creditors, the banks, the people who have collateral. Those are the main players in the Chapter 11. In a Chapter 7, a debtor throws everything into the basket, and a court United States Department of Justice appointed trustee takes over. Debtor people are out of the picture. Now that's why you can guess why people like Chapter 11, because why should debtor step out of the situation? He can control it. She can control it. So that's Chapter 11 and Chapter 7. There's also other pieces about the Federal Bankruptcy Code that I'll mention in a moment, but let me switch to state for a second. Under state law, you have receiverships. Basically, it's like a Chapter 7 in a way. It's just that it's state law, and you are appointing a receiver like a trustee to take over the business, either operate it or liquidate it. And then you have assignments for the benefit of creditors. That's another system under state law that's popular in some states. I'm admitted in Michigan, Illinois, and New York, but I've been in courts all over the country in the United States. I would say assignment for the benefit of creditors is extremely popular in places like Wisconsin, but while it's available in other states, it's not used as often. Then, of course, you have the third. Besides federal and besides state, you could also do your workout or your liquidation informally, just by agreement of the parties, without any court involvement, without even any state law. You can liquidate a business if your creditors agree with you.
If I can stop
Yes,
here, it's
please.
better to understand the situation. First of all, and I feel there is a big difference between Poland and the United States here. Assuming that my business is losing liquidity, I don't have enough cash. We are directors of the company. Is it our right to file a bankruptcy, or do we have obligation to file for the bankruptcy?
It's your right, it's not an obligation. That is definitely a difference between what I understand in
It's
Poland.
a Polish perspective.
Yeah.
Now, we're going to get into this with Michael a little bit, but as Bojana will tell you, everybody on the board has a certain duty to act appropriately and make good decisions. If you don't act appropriately and make good decisions, it doesn't mean that you will be critiqued for not filing bankruptcy, but if you destroyed the company in some way, or if you injured the creditors, we have brought litigation against directors and officers. We've sued them and basically sued them for not doing what they should do. Now, in America, most boards of directors are covered by insurance policies. So it's nothing personal. We're not really suing the individual.
But they are really paying these insurances because for me the mystery is if you really can get money from this.
Yes, and that's the important thing.
Okay.
And in fact, I've been in cases representing creditor committees where we got a lot of money because of the director and officer liability. Remember, you don't have to win your case against the directors and officers. What you have to do is make a credible showing, make it at least a good enough case that the other side has to defend, and then it makes sense for them to evaluate what will be cheaper, defending or just giving you a settlement amount. So again, I'm going to let Božena and Michael get into that in a minute. I want to go back to these three different levels, federal, state, and out of court, and to say that one of the reasons we choose federal often is because we have certain things within the bankruptcy code that you really don't get elsewhere. And first and foremost is something we call the automatic stay. When the debtor files bankruptcy, all actions for collection against it, all activity must cease. There's a big penalty if somebody continues to go against the debtor once it's in bankruptcy, other than by going through the bankruptcy court. So if you need to stop your creditors, recalcitrant creditors, you get that automatic stay. That's one of the reasons we use Chapter 11. A second thing that you get in Chapter 11, and in some states you get it under ABC law, assignment for the benefit of creditors, is the recovery of preferences. What are preferences? Well, sometimes in the 90 days or the year before the debtor files bankruptcy, it knows it's in trouble and it likes to pay off certain creditors. Or certain creditors know that the business is in trouble and they push to get paid. When they do that, if it's not according to the ordinary operations and ordinary terms, it might be possible for the debtor or the trustee to get back that money from creditors in order to distribute it to all creditors on a pro rata basis to make it even.
We have a similar notion.
Plus criminal responsibility on the part of debtor for selecting creditors.
Yes, so it's called skarga pauliańska, and it's what you just described. So if it was made on purpose just to make the assets a bit less.
It's also criminal responsibility.
Exactly.
Skarga pauliańska is really not about
civil.
Yes.
So let me finish with one more thing that is available in bankruptcy, but it's also available under state law, and that is the recovery of fraudulent conveyances. Fraudulent conveyances, you have the same in Poland.
Mm-hmm.
In our case, it goes back to Britain, to the Statute of Elizabeth from 1,000,000 years ago in the Middle Ages, when you could get back money or property or value that was transferred by the debtor for receipt of less than equivalent consideration, or which was deliberately transferred just to get it away from the creditors. Preferences are one thing, fraudulent conveyances are another. The bankruptcy code has its own fraudulent conveyance section, and it also, the bankruptcy code also incorporates state law on fraudulent conveyances. Maybe we'll get more to that later on, but if you're ready, we'll have.
Yes. Before I think we dwell into details of the bankruptcy law, what I suggest is now I'll give you some basics from the Polish perspective.
Excellent.
Of the situation. So first of all, we also have like European law and state law, which is by far away analogy, something similar to federal regulations and state regulations. But we don't have European courts. Everything will be tried in courts in Poland. Some things will be regulated directly by European legislation. Some of this European legislation will be addressed to countries, and countries are supposed to implement these regulations. Sometimes they do, sometimes they don't. Sometimes they do this with mistakes. Sometimes they do this with a delay. Apart from this, you will have state regulations, which is, I believe, something similar to state regulation in United States. As a court system, we will have common courts, we will have separate administrative courts, we will have some separate criminal, military courts, will be constitutional tribunal, which is obliged to express opinions if law is valid, if law is constitutional. We will have a tribunal stanu, which is more like political issue, I would say. Bankruptcy will be in normal, regular courts. It is not possible to transfer these issues to arbitration, but I believe it is similar like in United States, unless we have this informal bankruptcy, which you mentioned. I guess this is also possible to move to arbitration. When it comes to concept of liability of directors, so we would say members of the board under Polish law, the situation is totally different. First of all, Poland does not know the concept of board of directors, so one collegial body where will be executive directors, non-executive directors. We have two tiers, so basically will be separate body for executive directors, which we call zarząd. We will have separate body for directors supervising. Non-executive directors will be Rada Nadzorcza. And the scope of responsibility is totally different. The whole idea of Polish law when it comes to repayment of debts is that members of the executive directors, so members of the zarząd, are obliged immediately to file for bankruptcy in case certain situations occurs. If they don't file for bankruptcy, then we transfer the responsibility from the company itself to directors personally. So directors are personally responsible for debts of the company. This is something what is happening automatically. So basically, if you have final judgment against the company did not pay, you start to enforce this judgment against the members of the board. The question is if they can defend themselves. They can show, yes, we filed for bankruptcy in the proper time, then they are not responsible anymore. Then other scenario, they say, we didn't file, but it's not our fault. But this fault is understood very broadly in comparison to American situation. So basically, if you don't know Polish language and you say, I didn't understand what was really happening in the company, it does not really exclude you from responsibility to file for bankruptcy. If you say, me in the board of directors was just a favor for, I don't know, subsidiary company in Poland. I was just representing holding company from United States. I was in Poland once in half a year. It was not really my business. I was not signing any documents. Your problem. You were supposed to monitor the situation of the company. You should file for bankruptcy. If you say, I was sick, I was not really able to do this kind of things, then the court will actually, and there is judgment for this of the highest court, the court will actually check if it is really a situation will forbid you to manage the company. Giving some statement from doctor saying I was on sick leave is not enough for you to excuse yourself from this responsibility. And many other issues related to this. I don't want to go too much to detail, but the point is, it is very strict responsible for directors for filing immediately for the bankruptcy. It is not only against tax debts, it is also against normal debts from the commercial business. So the whole idea is that under Polish regulations, we don't wish to have these directors who in a situation which is not convenient for company, they do their best, they make radical decisions, they struggle for company. They are supposed to file for bankruptcy. Yeah. If they are not filing, we can take their home, their bank accounts, their cars as a responsibility.
In a worst case scenario.
In the worst case scenario. But it is also, at least in my opinion, as a litigator here, very standard procedure to seek the responsibility of directors. So how you said that filing against directors in United States, I would summarize what you said, has a little bit of a theater, that you are actually making a strong statement, showing that we are not joking with you. And then in the end, the insurance company pays the money. It does not work like this in Poland. It is normal situation to go to court. Moreover, when it comes to administrative debts, I mean like tax, for example, so like social contributions. We have even judgments of court saying it is a responsibility for tax office to pursue directors. It's not your right, it is your responsibility. And you can be, you as a government official, you can be sued for negligence if you don't do so. They do this automatically in such situation. Is radical, and the worst thing for foreigners who would like to be members of the board in Poland is that once it is happening, it's too late to defend yourself. Why? Because you already have a verdict against the company. The verdict is final. Then you make enforcement clause on the verdict. You start to vindicate this claim. There is no enough money in company. Then you go to court just to say, I want to vindicate this also against the directors. And this is not the time for directors to say, no, we question this debt. The time for them to defend themselves was in the time when the
first proceeding.
First proceeding. I don't want to go too much details. In some situations, for example, when the debtor was not a court verdict, but was some other kind of enforcement title, it is allowed for the directors to raise certain objections. But normally, if the enforcement verdict is simply court verdict, which will become final, you cannot defend yourself against.
So during the second proceeding, you need to only stick to the arguments concerning releasing you from the responsibility based on 299 article of the Commercial Code.
So, Michael Kwiatkowski, you've heard all this. Maybe you could weigh in on some comments that you have from New York about the principles that Roberts has been talking about.
Yeah, sure. Thank you. And thank you, everyone, for allowing me to join the panel. I really appreciate the opportunity. And yeah, I mean, based on what Robert said about the state of law in Poland when it comes to director and officer liability, it's certainly very different in the United States, particularly with the, I'll call it the penalty phase of it, right? Actually holding the director liable, because responsibilities of a director and officer sound like they're very much alike in terms of fulfilling your day-to-day responsibilities when making decisions. I mean, in the United States, kind of the two key fiduciary duties that a director has are, duty of care and duty of loyalty to the company. And the duty of care, raises the same issues that Robert mentioned in terms of the process of making decisions and making sure that you're informed and that you understand and that you spend time in making decisions that are going to guide the future of the company, and that you discuss those decisions with the officers, with other board of director members. So you have the similar type of process responsibilities, if you will. But in the end, the holding directors liable is very different. And the issue that comes up frequently is, who can hold the directors liable? Is it the creditors or is it the equity holders of the company? And what it comes down to is the financial well-being of the company at the time that the decision is made. So in very general terms, if the company is solvent at the time the decision is made, then the only individuals or the only stakeholders that can bring claims against the directors through the company, because these are derivative claims. Let me actually back up on that a little bit. So you know, with a company, you have what are so-called derivative claims. And those basically mean that somebody brings a claim against the director on behalf of the company. It's not a direct claim. It doesn't say, pay me. It's you harm the company. I can assert these claims on behalf of the company. So these are the derivative claims, and those are the only claims that are generally brought against directors. But going back to the timing of the decision and how it relates to potential bankruptcy filing and insolvency, when a corporation is solvent, the director's fiduciary duties, duty of care, duty of loyalty, are owed to the corporation, and those duties can be enforced, through derivative action by its shareholders, because those are the ultimate beneficiaries of the solvent corporation and its future growth. Now, when that changes, when a corporation is insolvent, and that's, when it's in, bankruptcy or it's, spreadsheet insolvency, in that situation, those fiduciary duties continue to be owed to a corporation, but in this situation, the creditors now have standing to bring these derivative claims against the board of directors on behalf of the corporation. So, not surprisingly, the determining solvency is a significant, factual issue frequently, and we have. Yes, sorry, Michael.
I was just going to say, so when the company is solvent, the creditors haven't been injured because it's solvent. And it's the equity owners that are going to suffer from the mistakes. But when the company is insolvent, then the creditors are the ones who do get injured, and that's why they're given first place in line to make those claims. Is that about right?
Right. That's certainly the policy justification for the law. What makes it interesting is about 15 to 20 years ago, there was a debate between the different courts about what happens within the zone of insolvency. So not quite you're solvent or you're insolvent, it's you're having trouble, for example, you have a company that can't get a loan from a traditional commercial lender. So there's some issue with its financials, but it might not be quite, insolvent, if you look at the balance sheet or, look at its cash flow or its capital, but you have potential issues. So in 2007, an important court in Delaware, which Michael alluded to the fact that a lot of these laws are based on state law, and for corporate law, Delaware courts are very important. They generally set the trend for corporate law that a lot of other courts follow. And so in 2007, Delaware court said fairly definitively that if the company is in the zone of insolvency but not quite solvent, the creditors do not have a right to bring derivative actions in that zone. Obviously, this brings up a lot of factual issues and potential litigation as to when the company crossed into insolvency to impose those liabilities on the directors. But certainly experts are frequently called in to opine on the solvency of the company, and frequently the directors, if they're concerned about the solvency of the corporation, will bring in financial advisors, will bring in attorneys to provide guidance and opinion about the solvency of the company, as well as the creditor, the responsibilities of the directors. With that, I mean, in the U.S., there's a number of different ways for directors to mitigate their potential exposure and liability. Like I mentioned, bringing in experts is one of the ways to do that, especially if there are potential conflicts of interest on the board. Frequently directors that sit on the board of directors might have conflicting interests that might arguably make the possibility of questioning the decisions more likely. So if for example, if one director is on two sides of a transaction that the company might enter, i.e., he sits on the board that's going to approve a transaction with a counterparty that he or she might have a interest in. So that's a potential conflict. So in that situation, the board of directors might want to bring in an advisor or an attorney to opine on that potential conflict. Another way of mitigating potential risks for directors and limiting their exposure to potential liability is make sure that they're educated on insolvency issues. Another good option is to also potentially involve stakeholders, some creditors, in discussions. This could be informal. And obviously it's only when appropriate, but it's also a possibility. And also making sure that your corporate formalities are observed, that you have detailed minutes of the board of the meetings from the board of directors, and you document the basis for those decisions, so you have that cover.
Can I interrupt just on that one point? I'm so glad you brought that up, because it's perhaps one of the most interesting things that happens in cases, especially involving smaller and family-owned companies. And Michael's phrase, maintain corporate formalities. We've had a number of cases where we represent the creditors.
Mm-hmm.
The company doesn't have any assets or too little to pay creditors, but we discover that the company's assets have been used to pay personal expenses of the owners.
Mm-hmm.
And then we can proceed against those owners. That would be under either concept of fraudulent conveyance, or under English law, American law, we have concept of piercing the corporate veil, alter ego. You probably have that here, right?
Yeah.
Yes.
So we pierce the corporate veil and we find out that another company, which was a sister company to the debtor, actually was interchangeable, and so then we can go after their assets.
Well, from Polish perspective, some of these strategies, they would not work. So basically, first of all, we cannot, under our concept of zarząd, we cannot divide responsibility between different directors. We cannot say you are the chief financial officer, you are chief security officer, you are chief executive officer. So basically, the one who is responsible for monitoring liquidity is chief financial officer. All members of the zarząd are equally responsible for financial issues. So having minutes from board of directors will not help us. Yeah. So basically saying, I executed this credit agreement just because it was a resolution of the board, and board, without any vote against it, voted for this credit. So what? You still can be personally responsible. This is one thing. Other thing, having some agreement with the company saying your scope of responsibility is this and this, has only civil effect. You will not use this agreement in relation with creditors, but also in case of criminal charges, which can follow. For example, for unpaid taxes, you will not use this agreement to exclude yourself from potential responsibility in this area. So I see this situation totally different. Yeah. Also, a resolution of shareholders does not really exclude you from responsibility. It means only that those shareholders in future, they cannot bring action against you if they voted for you, but that's it.
I mean, we need to make it clear that we are, from Polish perspective, we are really strict and formal. So our responsibility, our subsidiary responsibility of the company's debt depends only on the articles and what it said. So if there's going to be a misconduct or not, if that's going to be the director that led to such a debt, it's irrelevant, really. So for us, it's just if he should file for bankruptcy and did not do so in given term, That's it. The gate to the subsidiary responsibility is open. Even if he just was appointed as a member of the board, and that's the first thing that he did, but he was late, for example, 2 days, because it's not if you do not fill the petition, even if you do it after the time. So that's why there's another subject of when the insolvency status really arises, so important.
Yes.
Because on that, it depends if we made it in time or not, and if there's going to be a possibility to enforce those debts from us as members of the board.
Thank you. So I interrupted Michał, and I'm Michael. I wanted to let you continue because I know you're having a fire drill in Garden City. So let me get back to you, Michael.
No, actually, I had a question based on the conversation about Polish law, and so what would a director look at in terms of determining whether or not to file bankruptcy? I mean, would it just be a solvency or insolvency calculation, or would there be, what considerations would go into that calculation of when or if the company needs to file bankruptcy?
And what is insolvency in this country? Is it balance sheet or equity test?
We have different premises for the insolvency. So there are like some options concerning like how is the accounting like provided or led by the company to check if the insolvency status is on or not. So if I'm not regulating my invoices in time, if I have some debt that exceeds, for example, I'm not paying for 3 months for some repeatable payments, that's the premises for us to check or to determine if that's the time for us to fill in the petition or not. Those are like the general rules, but each time we need to check it individually, of course.
But what is important, I think, in questions or case of question of Michael, is that it's not if you didn't file, you start to be responsible for all debts. You need to have a court verdict. This court verdict cannot be actually enforced. Why? Because the debtor does not have enough funds. Then you check. If he's insolvent, it seems that he's insolvent, the bankruptcy was not filed in time, then this particular debt, which is confirmed by the court judgment, can be vindicated against you. That's it. It's not that from this moment you are responsible for everything what happens in the company.
Yes, sure. And one of the premises that the member of the board can release themselves from the responsibility for the company's debt is that even though they do not fill the petition in due time, there's no damage because of that. So it's also like the one of other premises that Robert started to describe, which can release us from the responsibility. Because what Michael Katkowski said, like the responsibility concerning the misconduct and the possible enforcement from the other shareholders, that's totally different thing. The responsibility arising from not filing the application in time, it's our, I believe, special institution.
Or European institution. It happens in other countries, but definitely it's not a common law thing. What I want to inquire you is also a question of a timeline, because I know that in common law countries, the idea how to proceed with the bankruptcy is totally different. In Poland, it's something very slow. So basically, you are losing the control of the company. Generally, the court procedures in common courts in Poland, they are very slow. When it comes to regional courts, it's, I believe, 17 months on average. In district courts, it's something like 10 months on average, but you will have cases which are much longer, and then you go to the Court of Appeals, which is even longer. I don't count the highest court because it's a court of law.
So your question is, when do you file bankruptcy?
Yes, and how quickly you proceed, because in Poland you start the procedure and it takes years, many years.
Okay, so if I can respond to that before returning to Michael, but Michael, you can add to what I'm having to say. Interrupt me if you like. First of all, my experience is that companies will file bankruptcy only when they've reached a crisis point. And that crisis point is going to be basically most situations where they're being sued and they have to stop the lawsuits, or they're hemorrhaging terribly, losing money, use the expression hemorrhaging, it's usually at a crisis point. Sometimes companies file bankruptcy just to accomplish a sale. And that is not an emergency, but it is well planned in advance. They know they want to do a sale. The buyer wants to buy the assets free and clear of liens that are there. And one of the ways to do that is to go through a cleansing order procedure in the bankruptcy court. But I would say that most of our experience in recent years would say that it's a crisis situation. For example, with the archdiocese around the country, they're being besieged, or the Boy Scouts, they're besieged with litigation, and that's the best way to deal with it, to file the bankruptcy. Michael, what would you say?
Yeah, I tend to agree that it's a crisis situation because you don't, as the debtor, you do not want to have a state court judgment entered against you. Most bankruptcy courts will not overturn that judgment. So once you have a judgment for millions and millions of dollars, you've lost. So generally you would file bankruptcy, even on right on the eve of the state court issuing that potential judgment, to prevent the entry of that judgment. So you can try to negotiate or litigate it in the bankruptcy court rather than have a judgment entered against you and being stuck with it, for lack of a better term. There's a well-established federal principle that federal courts will not overturn state court judgment. So I mean, absent some sort of a fraud or some significant issues with it, but a regular judgment will not be overturned. So I tend to agree that it's a crisis situation. And then it really depends how long you stay in bankruptcy. It really depends on what your plan is. I've seen debtors get out of bankruptcy in a few months because they come in with a prepackaged plan that they negotiated with creditors. And so it's all about cleaning things up and getting the plan approved by the court. And most of the significant stakeholders, most of the creditors, and frequently the equity holders are on board with the plan. And so that's a quick process. And those are frequently the larger cases that you hear about are those types of cases, because you don't want to risk going in on those larger cases without a firm plan in place. The smaller cases, the mid-sized firms, that could last up to you're supposed to propose, you're supposed to meet certain benchmarks within the process. So it's either 180 days, 210 days, by which you're supposed to, propose a plan and confirm a Chapter 11 plan. But it's generally not years. Unless there's
we start with years and
Back in the last century, when I started practicing law, we had cases that were around for 10, 15 years. It took forever. It was an annuity for the professionals, so they were in no hurry to get the cases finished. I remember coming in when there were still Bankruptcy Act cases still pending from even before my beginning. But first of all, today, even in major bankruptcy cases, they move them along much more quickly. And then in addition, to help small businesses avoid the costs of going through the process, and it's rather expensive, we had Congress introduce several years ago a small business Chapter 11.
Okay.
Commonly referred to as Subchapter 5 of Chapter 11. And it's made for businesses who have debts of a certain level, the smaller ones, so that can move even more quickly. Michael, I know that we're going to run against time and we need Boženas to be participating, but any last points you want to make at this point?
No, I think it's been very interesting, and certainly seems like being a director in Poland is much more
dangerous.
Dangerous, yeah.
That's why what Michael suggested, even that, as I pointed out, it's a different kind of responsibility. It's really wise for the Polish director to cooperate with some experts concerning like the accounting of the company and checking if the time is now or not. So to be always sure on what we are standing right now.
Right.
Okay.
And that's the question is, how popular are, financial advisors and attorneys when it comes to advising courts? I would assume very popular.
Yeah. And how careful they are with like the limits of their responsibilities in the company. That's why they're so important, and that's why they are a bit scared.
Right.
Very good. So with that, there's another kind of responsibility that one might encounter, and that's related to taxes. Božena, tell us a little bit about that, please.
Hi, everyone. Thank you, Michael, and thank you for having me on the panel. Yeah, so the responsibility for taxes, it intertwined with everything that we just discussed about corporate officer director liability and the concepts of fiduciary responsibilities, duty of loyalty, and the necessity for reasonable decision making in the context of a corporate governance. The one thing I will bring up really quickly is in the United States, we have a variety of entity types. Obviously, one of them is a corporation, which I'll discuss in just a moment. We have LLCs, which are limited liability companies. We have partnerships. We have S corporations, which are smaller corporations. And we also have sole proprietorships. And all of these entities are taxed differently. But, there's in a corporate context, there will be a director and officer liability or could be potentially, I'll discuss that in a moment. In a, for example, limited liability company context, the question is, is there responsibility? What's the responsibility of the members or partners of that partnership? So in a corporate context, right, under U.S. law, a corporation is really its own person, right? So it's taxed as a separate entity, and as a result of that, the corporation itself is liable for any unpaid taxes of the corporation. Now, when I say any, I mean corporate taxes, right? We have the concept of corporate taxation, where the corporation pays a tax at the corporate level. And then when money is distributed out to the corporation's shareholders, the corporations will pay tax on their income from those dividends. But that's a separate issue from the corporate tax liability. So in general, partners or owners or shareholders of a corporation would not be liable for corporations' unpaid taxes. Now, as you know, with tax law in the United States, there is always an exception to the rule, and then there's the exception to the exception, right? So the exception to the general rule, the exception to the general rule is, for example, a corporate employer will be required to withhold what we call payroll tax withholdings, right? Federal income tax withholdings from the employees' paychecks, unemployment tax. We have something called the unemployment fund, to which employers have to contribute by either contributing to it out of their own funds, or a portion of it comes out of the employee's paycheck. We also have Social Security taxes, which is a Social Security pension fund, right? So that's a contribution to Social Security that also comes out of the employee's paycheck. When the employer fails to withhold those taxes, and we call them in general terms trust fund taxes, when the employer fails to withhold those, or let's say the employer does withhold those taxes but fails to remit them to the government, that's where you will have liability, which can now transfer to the person responsible. We call them it's the responsible person concept, and that person can be held personally liable for the corporation's trust fund taxes, right? So it's a big deal. And actually, I am actually working on a case currently where we represent a company where the company had a chief financial officer who was responsible for administering all of the payroll withholdings. And that person effectively defrauded the company, defrauded the company and never sent the money over to the government. So the money was withheld from the paychecks of the employees, but it was never remitted over to the government. And the IRS is now coming after this company, including the primary owner, shareholder of this company. This happens to be a sole shareholder company, coming after her. And we're defending her and the corporation now in this this whole situation, because she really was not even aware of anything that was going on. And so the question is, well, should she have known? And what should she have known? And what was the responsibility that she had as the owner of the company to know that she was being defrauded? And should she have detected it earlier? Right. So all these issues come into play in trying to determine whether she might have personal liability and whether she really overlooked it. Was she being not careful enough? Did she really not have a way to find out because she entrusted her payroll administration obligations to this individual, and she fully trusted him and relied on him, right? So then there's this issue of reliance, and where's that line drawn? Is this reasonable reliance, or is she going to be personally liable? But in a corporate context, you definitely could have this type of a personal liability for trust fund taxes. Another example would be a business that sells at retail, right? Retailers are required to collect what we call a sales tax. So you come into the store and you're buying a pair of shoes, you're being charged the sales tax of 8%, let's say, right? 7%, 8%. And the number will vary by state. Each state will have a different sales tax. Some states won't charge a sales tax on certain items. But let's say that you're being charged the sales tax. That money is not the money of the company. That's money of the government, right? That's a sales tax that is remitted on the sale that now has to be paid over to the government. Again, if the employer does not, or the company does not remit that tax, the government, whether it's the state or, the federal government, in case of payroll taxes, will come after the company and could well come after the individuals that are responsible, depending on the situation. Now, is it easy to charge personal, individuals with these types of personal liabilities? It's not. And that goes into the conversation that Michael and other Michael just had. We have something called piercing the corporate veil. There's pretty high standards in terms of having to prove that this individual was personally liable, right? We have directors and officers obligations, but are they reasonable? Are they stepping out of bounds? Are they defrauding the company in any way, shape, or form? And then, of course, we have directors and officers insurance, which will protect them, in situations like these, unless it's fraud. I don't think fraud is covered. Any kind of intentional, disregard of rules and defrauding would be covered under D&O, but anything that's not intentional generally would be. So then we have entities like the limited liability companies, right? Again, a limited liability company is, in a way similar to the corporation from a liability standpoint. It really offers this limited liability. However, it's taxed differently. Tax purposes, it's called a pass-through entity. And what does that mean is that the entity does not pay an entity level tax. The tax is paid at the individual level, right? So the profits in an LLC will pass through the corporation onto the individual members. However they're divided up at the member level, those profits pass through, and then that member will pay their own federal, state income taxes on the income of that company. Again, however, there's the trust fund taxes, right? And the same issue comes up again, because they could be liable for trust fund taxes that the LLC does not remit to either the state or the federal government. So, there's definitely liability from a tax perspective. It's probably not as easy. I don't know what the situation is, how it works in Poland. Maybe you can elaborate on that. But it's not easy to come after individuals unless there is really intent to defraud or a complete disregard of rules and regulations. So we have these corporate protections at the corporation or entity level, but definitely when it comes to trust fund taxes or individual liabilities, there's definitely a possibility to have to pay. And interest.
If I can stop you here, ask a question, because here in Poland it's quite popular to register these LLC companies in the United States, in certain states, as a way, I would say, popular wisdom how to save money on taxes. I will not go to details of this concept from the Polish perspective, which actually is more or less wrong also, but it is not the point. The idea is that we have a lot of advisory services saying like this: if you have LLC company in the United States, which will be tax transparent, it will have a single member, and it will not do any business in the United States, then basically you don't have absolutely no obligations in the United States, apart from paying franchise tax to the state authorities once a year. I wonder if you could tell us if it is correct perspective, or you see certain obligations such company has to fulfill anyway.
So from a corporate formation standpoint, LLCs are a good choice, both for foreign investors coming in and for domestically from our perspective. However, LLCs are there are certain types of businesses that, for example, real estate investments, right? If you're coming in as an investor in the United States and you're going to be buying real estate or investing in real estate transactions, definitely the recommendation would be a limited liability company. So yeah, there's a lot of flexibility with limited liability companies. There is this pass-through concept of taxation. It does not necessarily mean that your taxes are going to be lower than if you're a corporation, and here's why. The corporation will pay a 21% tax on its income, and then it will distribute that income out to you. You may or may not, right, have to pay tax on it. If you're not paying tax on it in the US because of a treaty, let's say between a tax treaty between the US and Poland, you will pay tax on it in Poland. I don't know what rate you would be paying on income that's passed through to you from LLC, but I can tell you here, any dividend income is taxed at 15 to 20% at the federal level, and at state level could be even more than that. And then there's something called net investment income tax, which is another 3.8%, which could add on top of that. So you could be still in the bracket, of 20, let's say even if you're at 20%, your entity paid 21% tax on its income, and then it distributed leftovers to you, and now you're paying 20% tax on top of that. If you're a corporation, if you're not a corporation, if you're just a pass-through entity like an LLC, the income is not paid at the corporation, at the entity level, but you're still paying tax at the individual level, right? And our individual level rates could be as high as 40%. So I'm not sure that,
can you just check if the connection does not froze? Because I can see one of the attendants, he's not moving, and probably connection.
Our connection's fine.
Yeah.
Somebody froze it.
There was a pop-up concerning that we need to restart the connection, and I'm just making sure if everything's fine.
Jenna, you hear us okay?
I can hear you okay. Can you hear?
Oh, okay.
Yeah, we heard you fine.
Yeah.
We're good. We're good.
All right.
But I do want to point out, it's now 10 o'clock New York time, 4 o'clock Poland time.
Sure.
We wanted to do a 1-hour program this first time, and then we wanted to have Q&A.
Yeah.
So if this would be a good time to ask, I know Wojtek Jung is on this presentation here. If he's still alive, because his picture isn't showing, I wanted him to introduce himself. Wojtek, are you there?
Well, thank you, Michael. I'm actually in a taxi right now in Washington, D.C., so you may lose me, but I found this conversation to be very informative for a number of reasons. First, I frankly don't know much about Polish law, so this is helpful, but maybe more important, from time to time, I have been asked by American companies with Polish subsidiaries whether or not I want to be a board member, not quite a Hunter Biden scenario, but to be a board member of a Polish subsidiaries. And I had frankly no idea of the risk that Polish directors may actually have. So at least from my perspective, I found this very informative. Michael, your presentation was fabulous, as well as the teams. So thank you for sharing the invite with me, and I look forward to your other presentations down the road.
Thank you. I want to point out that Wojtek was kind of my client in a merger and acquisition situation. I introduced him to his wife.
Oh, okay. Because what you bear in mind, that's the part one when we highlight the risks. The solutions would be going to be in the part two. So stay tuned.
And obviously, one of the messages we want to get across here is that Robert and McCoy are the people to go to on the Polish side, because they have this great working relationship and knowledge both ways. So we like to work as a team when we can to help people.
Sure.
Are there other people who have, there's another Wojtek on here, and do we have others who would like to speak up? Please do. And if not, what I'd like to do is say, I think it was an interesting, very interesting discussion, and I think it calls for more. So perhaps we can do chapter 2 sometime in the near future.
Yeah, why not?
Definitely, yes.
And I want to also thank Bożena and ask her if she has any final words she'd like to add.
No, thank you. This was very, very informative. And, you know, if anybody has any questions regarding the overlap between US and Polish tax laws or anything involving taxation, I'm more than happy to answer questions even after this seminar.
And you can even answer in Polish if they have questions.
Polish, yes.
Very nice. And Michael, I don't know if you're still there. Ah, there you are.
Yes.
Any last words?
No, but I look forward to potentially working with you guys. I know that Michael has a good relationship with your firm in Warsaw. I'm originally from Warsaw. I was born in Wola, in lifelong Legia Kibic. I wish our national team, the match that starts in 2 hours was a little bit more important than it is, but you know, we'll deal with that. But you know, I look forward to you know, potentially working with you guys and hopefully meeting you guys in person. So
Great. And
Likewise.
McCoy, last words?
Yeah, likewise. I look forward to our cooperation. I believe we have a lot of potential, and due to our expertise, knowledge, and experience, we really can help our clients in a broad spectrum of cases and projects. And I also believe that's a great part one. And right away we get into the details, into the practical cases, and that's what I like, because we always can look up for some provisions for articles, but day-to-day cases are the best to really show the potential risks and later on how to deal with them and how to look for a solution.
By the way, before we conclude, I'd also like to add what you just said. Telling some of our war stories would be a wonderful way to share some of our experience and some of what the law means. And we don't have time today to get into all the different examples, but that might be a good title for our next presentation. And
I just try to diplomatically say everyone can read, but our war stories, as you call them, are the real knowledge and experience.
Robert, our leader.
Yes, so if there are no more questions, I would like to thank you all for your attention and stay tuned for the next part, next episode.
And thanks to Carolina for all her work getting us ready for this. Thank you.
Yeah,
Thank you very much.
Thanks, Bożena. Thanks, Michael.
take care. Bye-bye.
Bye-bye.
Thank you, bye.